A very good morning to one and all present in this webinar today. It gives me immense pleasure to welcome you all on behalf of the firm Mehta and Mehta to this Saturday webinar. So, the topic for today's webinar is analysis of selected adjudication orders passed by ROC vis-a-vis the role of a company secretary. A topic that holds a lot of significance, especially in today's time, where the roles and responsibilities of a company secretary are increasing day after day. Our presenter for today's webinar is CS Professor R. Balakrishnan. He is a person who requires no introduction. For anybody who has seen our Saturday webinars would know Balakrishnan sir because he has been an important part of all our webinars. Balakrishnan sir is a highly respected company secretary, bringing nearly 4 decades of exemplary experience in secretarial compliance. A significant part of his career was with Fusco India Limited. In addition to his professional achievements, Sir is a sought after speaker at ICSI CCGRT, where they regularly share their wealth of knowledge and insights with the next generation of professionals. The contribution towards various magazines, including the Chartered Secretary of ICSI, further highlighting his commitment to advancing in the field. His writings not only reflect the deep understanding of the industry, but also his passion for fostering professional growth and development. Thank you so much, sir.
Yes. So, our panelist today is Mr. Chandan Mahapatra. Welcome, sir, and thank you so much for being there with us through your busy schedule today. Also, I think you said you're in court, but still you're taking out the time to be here on this webinar. It is really an honor for us. So, just to introduce him, Mr. Chandan Mahapatra has over 3 decades of experience in domestic and MNCs, spinning manufacturing related to FMCG and automobiles, financial services, retail and corporate lending, and backroom operations related to finance, commercial operations, and taxation. He is currently the company secretary and compliance officer at Atlas. He has extensive experience appearing before regulatory authorities such as SEBI, relating to adjudication and settlement, RBI for any FEMA related matters, Registrar of Companies for complaints, compoundings, and approvals, and also handles tax appeals before the appeal commissioners and ITAT, DGFT, and excise and customs. His litigation management covers civil and criminal cases before trials, special courts, high courts, and tribunals as well, related to adjudication, appellate, NCLT, and DRT. He regularly contributes to the professional journals on corporate law, finance, and accounting, and is a guest lecturer and speaker at ICME and law firms. He holds honors degree in commerce and law and is an associate member of Institute of Cost and Management Accounts of India and a fellow member of our own institute, which is ICSI, and an ISO certified internal auditor. Apart from all the professional laurels that he holds, uh, he also Chandan sir is also a passionate photographer with training from Nikon and the Delhi School of Photography, which is his passion related to photography is quite justifiable and as well as evident from this. His works have been published in leading newspapers like the Hindu, Times of India, and Air India travel magazines. He is socially a very conscious member and he runs a YouTube channel and engages in photojournalism through Voice for the Voiceless. Thank you so much, Chandan sir. Thank you for being here. And I would now like to hand it over to you for opening remarks, and thereafter, I would request Bala sir to carry on with the presentation.
Thank you so much, Jasween, and also Mehta and Mehta for inviting me for this webinar. And obviously, Professor Balakrishnan is very, he would be really, doing justice to this topic. So I have very little to add on this, because when you have such an august presenter, my work becomes very easy. But having said that, I will start with a small caveat, because my role as a panelist, I don't have an advisory role here, nor am I going to take any legal position on any case laws. What I understand, or what I feel from my understanding of the adjudication process, is that there are certain hygiene issues which I would like to highlight for company secretaries, because it's become a very serious profession as compared to what it was earlier. And they say, like, prevention is better than cure. But in this uncertain world, it's easier said than done. I would say what is more apt is settlement is better than war, and litigation, in my understanding, is no less than war. You know, so when you say settlement, I also mean compoundings and all that. And the other thing which all company secretaries like us should keep in mind, that we were very happy when the Companies Act 2013 brought in the concept of KNP, and we were elevated to a equivalent structure in the corporate governance of a company. Then 205 also talked about functions. Then very recently, SEBI, it is LODR 2015, as well as its circular on compliance officer, has also further strengthened this. So we need to understand what is actually a company secretary. If I go by the SEBI regulations, company secretary is not one job. It divides into three different roles and responsibilities. One is a pure company secretary, which all of us are used to from the day the ICSI Institute came into being. The other is a compliance officer, and the third is an amalgamation of a company secretary and a compliance officer. And the third is the most difficult one. We never realize that it's absolutely different. A company secretary and a compliance officer are two different genres. They are not as simple or as mundane as it seems at first glance. Because you are stepping into a realm of law as a compliance officer, and which means that you are equivalent to a legal professor, be it an advocate. Advocate obviously, is practicing in the courts, but you are equivalent to him. So which means that you should have, very good skills of how to do legal research, briefing, because see, any outside consultant lawyer is as good as your brief is, because you are the guy who understands the nuances of your company and most of the matters connected there too. So it's your briefing which will tell you where you are going to be in your settlements or compoundings. Then you have drafting skills. You need to be very good at drafting, because the first level of defense a company has is a compliance officer. Before an SCN or a show cause notice is issued, there are certain exchanges which happen between the regulator and the company, where the company secretary or the compliance officer is the face of the company. How good he puts his pleadings, how good he makes his applications, will decide how serious the SCN would be. It could be dropped even at that stage. So he would have to maybe even be good at representations, because he would be meeting quasi officers of, say, ROC or SEBI at regional officers. So he should be good enough to know the law, to put it across, so that the regulator, and I tell you this with lot of strength, in many cases, I have, in my personal appearances, I have been able to convince the officer to drop the charges, because our case merited it. And that was because I was very strong in my drafting, pleadings, and representation skills, because I knew the law and I knew the company. And you should come very strongly to a regulator that you are honest in your approach. If you have made mistakes, if the company has made mistakes, I would say don't fight it, compound it. That's the best thing, because it will haunt you for the rest of your life. So a company secretary now has to look at this, when Bala sir talks about adjudicated orders, that is the final stage. Before that is all this. So in my understanding, you need to get your ground on a very strong footings to really ensure that you come out well. Your company gets a good opportunity to represent itself and put up its presentations or its applications in a proper manner. So that is what all I have to say. No, I don't want to take too much time because Bala sir all the selected adjudication orders. And thank you so much again for the invite. Uh, that's all I have to say, Bala sir and Jaswin.
Right,
Thank you
Chandan.
so
Thank you, sir.
You really touched upon the very, very integral issues of the company secretary. And you also touched upon what are the things we need to be prepared before we reach the final stage. As you rightly says, adjudication is the end of the matter. Maybe after that, there is one more stage. If people have a merit, they can go on appeal. Otherwise, that is the end of the matter, which put the almost a stop to the dispute. But how to avoid the dispute, how to get the things that the initial stages you touch upon very nicely. One more thing is there, when we took up the profession initially, people were all like thinking, oh, what is there? Who's the company secretary? Our visibility was not even known in the company. Oh, who is this person? Oh, company secretary, koi baita hai. It is something like that. But today, which is not the case, today the regulators who are looking, the way the regulations are coming up, especially Mr. Chandan touched upon the SEBI regulations, which was brought on 12th December, the amendment which has elevated the level of the practicing people and as well as the employee people actually together to a very high pedestal of the level, bringing to the highest things, treating in par with the statutory auditors, appointment by the AGM for the secretarial auditor for the listed companies. Days are not far away. This will happen for the other companies as well, because probably the Companies Act will get harmonized that of the listing regulations, and this will actually happen in the years to come, definitely. So these all the things which are actually giving the elevation. So when it is there, our company secretaries need to raise our bar. That is the one thing. Because yes, it is always good reaching a stage where the nil non-compliances is there. That is an ideal situation, really, really speaking. But after all, one thing is that we are all human beings. Mistake can happen. Maybe inadvertently, maybe missed out very certain circumstances. It might happen. I'm not saying it cannot happen. But how to avoid to the greater extent, how to set right the thing, those are all the issues which are there. But the way I see the adjudication orders which are coming up, the non-compliances, which really, really bothers because, very trivial issues. As we go along, you'll actually see it, which is happening. Another thing, I also had a mind of analyzing the orders. Now, what is happening? There's all these trivial issues mostly happening with the private companies. When you say a private company, I call it actually the husband and wife company. Because limited people, they do the things. They want to get the business done. That is the thing. And they are not required to employ the company secretary. Really speaking, the guidance and other things are all lacking. We are taking the help of the practicing people as and when it is needed. That is what it is happening. In fact, really speaking, practicing people also should hand a helping hand to the private companies, giving, sort of a checklist, having a periodical meeting and tell them what is required to be done, etc. That will strengthen our profession because the way we are gaining our importance, the way we are being recognized and other things are all. Not only that, more and more regulators are also looking the company secretary profession in a high pedestal. They are really, really looking, they are making the company secretary really responsible for the compliance. So nowadays, the orders which are actually coming either from the different ROCs or even from the audits, which are all talking about the compliance officer is the company secretary's basic responsibility is compliance. And they are also referring the various guidance note issued by the Institute of Company Secretaries. Our institute has been doing a wonderful job in bringing out not only the secretarial standard, but also bringing the various guidance notes. These guidance notes have been actually referred by many orders and saying that what we are expected to do. I think with this, I'll just take you through. What I'll do is let us touch upon what can go wrong. What can go wrong? Rather than that, I will take up what has actually gone wrong with the reference to the decided case laws. That is number one. Number two, then we can also see how do we actually set right this thing. As Chandan sir actually puts it, there are three different ways of settling the matter. One thing is their adjudication process. Adjudication process, either we can wait, they can themselves come back and issue the show cause notice, we proceed, or upon realizing we ourselves can file a suo motu application, adjudication, seek for the adjudication. That is one of the way of sorting out the thing. And the second thing is there, yes, wherever there is a permit reasonable reasons is there, we can apply for the continuation of delay, set right the thing. There are something which cannot be set right, there are something which can be set right. Suppose you miss out the holding of the annual general meeting in time, that cannot be set right because the date is already gone, time is already passed away. There's nothing. But at the same time, certain filing of the forms are missed out, certain documents filing is missed out, etc. Other thing, and delay has happened. Yes, this can be done by seeking the continuation of delay, those cases. So people have to evaluate where the continuation is possible. We can apply for the continuation, justifiable reason, get the thing set right. Because always it is said, rather than the non-compliance, late compliance is better than the rather non-compliances. That is one thing which is there. Of course, the compounding is a specific issue where, the certain matters which can be compounded, certain matters cannot be compounded, that is there. But now with the adjudication officer have been given the powers to adjudicate the matter within the given framework of the law, fixing the penalty, etc. Most of the things are all going under the adjudication order, except where the compounding is actually called for. We'll touch upon. Then probably I'll take you through some of the decided orders so that will give you an idea about the heavy of the penalty, etc., which is levied by the ROC. And not only that, since we are discussing on the ROC orders, we cannot overlook the SEBI also. Because nowadays, SEBI also taking up the matter left and right on various issues. And not only on the company-related matter, it is on the non-appointment of the company secretary, independent director, constitution of the committee, etc., and other things under LODR regulations. And plus, cases relating to related party transaction, cases trading regulation, those cases are also very much actually coming up. So what we'll do, we'll also take up some few cases which is decided by the SEBI as well, and then we'll proceed. Let me start with that. You are all aware actually change is permanent. Nothing is permanent except the change. So we need to change ourselves. Whatever happening is there, that is why various amendments which are actually happening, various things are happening, various developments are happening. We need to change our style of working. We need to change ourselves. That is one thing. Second thing is, I remember of Peter Drucker, who is our management guru. Those people will be knowing it who are studying the management course, etc. and other thing. He said doing the right thing is more important than doing. That means it actually comes out. Efficiency is doing the things right, but the effectiveness really comes in doing the right thing. I'll put it that way. As company secretary is actually concerned, as we know, Chandan sir also said very clearly, our company secretary is actually becoming more and more complex with the changing circumstances today. Because role of our company secretary in the employment is increasing to the greater extent. He is not only responsible for the compliance, but also he is responsible for the governance, statutory records, supporting the board. He is becoming an advisor. He is rather a charioteer who actually, like Krishna, who charioted the chair for the Arjuna and advising him from, he was not participating in the war, but he was actually rendering the advisory services. He was actually charioteer. So company secretary should be a charioteer to the board. That is what I will actually put it. When it's come to the practicing, yes, practicing now the scope is increasing over a period of time. Various provisions are there, multiple acts are coming, where recognition is happening from time to time. So again, here, because one thing is that PCS is doing multiple activities with multiple companies actually. He can represent with the various regulatory authorities, various restructuring processes, and again providing the professional assistance where he is actually signing the various documents relating to the companies, etc. All those things he is actually doing it about our profession actually. I said really, our institute, many institutes if you see across the world, they have changed the institute's name itself from Company Secretaries Institute to the professional institute, governance professional institutes. Because it has been happening, because today the UK Chartered Secretary and Administrator Institute is one of the governance institute. Same with the case of the Australia, New Zealand, and other places actually. I think in India also that might actually happen. And increasingly people are actually recognized as the governance professional. Those of you who are member of the institute in UK, you may be knowing, they already advised that you are actually now known as the governance professional rather than the chartered secretary, and all those things are there. So really speaking, there are many things people already, you may be knowing it because you are all in the profession, you are all doing the thing. You may be already working with the maker-checker system, you may be having a checklist, you may be having your own ways of ensuring the currency's accuracy. But above all, is what we need to look into, really speaking. Only thing is, yes, we need to take utmost care, understanding the law, rightly interpreting the thing. That is what it is required to be done. Look how the regulator is actually looking. In fact, you all might have seen also there is a decided case law from Madras Fertilizer, which is one of the listed company, which is actually a government company rather, where it was there in South in Chennai. And in one of the annual general meeting, I think during the COVID time, some people who are not personally meeting it, they decided to distribute gifts actually, because normally they call for the meeting, they provide refreshments, etc., and other things. This time they decided they will do it, they will provide a gift. That is what they have done. So gift means they have actually provided the credit card of the SBI credit card to the people, to all the shareholders. That is what it has actually happened. So here what has happened is, in this particular case, ROC has taken over the matter. They have issued the show cause notice to the directors of the company. And the director and the company, they were actually penalized for distributing the gift, but the company secretary was actually left out in this process. That is what it has happened in this particular case. Somehow the company felt it that, they will appeal against this particular order. They appealed against the order and they went to the regional director. When the matter came to the regional director, you will be actually surprised to know. Regional director looked at the order, and the very first thing is what he said was, he actually said the company secretary is responsible being a compliance officer, because the compliance rests only with the company secretary. That is what he actually said in this order. And second thing is, there what when the company secretary is actually appointed, it is his duty to take up the utmost care and ensure the compliances and with the secretarial standard. Here for the secretarial standard also here. So here is said in this particular case, in his opinion, there is only the company secretary alone will be held responsible for the non-compliance committed. And so directors and companies, they are not to be penalized. So what he has done is, he actually set aside the order against the directors of the company. And it is a very speaking order. You people can actually go through the order. It is very nicely said. He said very clearly, when the company secretary is appointed, the managing director, full-time director, and all things, they will assume company secretary will take care of the compliances. Their job to only concentrate on the business. That is what he has actually said here. And again, he also referred the same thing what Chandan Saab said, whatever the recognition. He also said company secretary also can be in this particular case. He is equally responsible. That is what he has said. Ultimately, he directed the ROC to issue a separate show cause notice against only the company secretary and proceed on this matter. To that extent, this matter is actually definitely, it shows very clearly what is the responsibility, what we are holding, what we are expected to. That is recognized by the regulator. That is one thing. And similarly, coming to practicing company secretary, many times what happens, the practicing company secretary audit report. Are we supposed to only comment only on the matter related to secretarial audit? What about the related party transaction? What about the insider trading transaction? What about the other regulation? All the things comes into. But the question is, under the Companies Act 2013, either the company in employment or in the practicing, we are actually responsible for the compliances under the Companies Act. That means everything. Nothing is actually left out. There is no carved out is there, actually speaking. If the related party transactions forming part of the financial, then definitely it is our job to see whether related party transaction compliance has been done, necessary approvals have been taken, etc., and other thing at all. This particular case, which has actually emanated pharmaceutical company actually. So what has happened is it's a Sun Pharma case. In the Sun Pharma case, the company secretary was issued the secretarial audit report. He has actually not brought out certain secretarial matter relating to related party transaction. Yes. So the so-called notice was issued to him, and he has been actually asked. What he said is upon the statutory auditor's report, because nothing in that there. So relying upon that, I actually made my report accordingly. That is what he has said. This is one of the order which I would say running about 15, 16 pages, where he has particularly referred the guidance note issued by the institute. There he said the practicing company secretary is supposed to examine the transaction during the period of his secretarial audit examination. He listed down what is there in the guidance note related to party transaction, excessive management remuneration, insider trading, intercompany transaction, IPO fraud, various policy, transfer of share, everything is actually linked out. He elaborately referred the guidance note, and also he has reproduced a checklist, which is actually given the guidance note saying that you are supposed to do this, have you done this? And he also said, okay, you can actually rely upon the certificate issued by the statutory auditor, but at the same time, you have to form your own opinion on your best judgment based on the evidence, based on your review, and you have to spell out. That is what is actually brought out in this particular order. So at the end, what has happened? He has been penalized 2 lakh rupees. Similar to the case with corporation also. This SR Shipping Corporation, one of the listed company, which is Ahmedabad ROC. In this case also, what he has done is he has not reported, let's say, various things which are relating to the related party transaction. Because one thing is there, apart from the related party transaction, there were other non-compliance were also there. Minutes books were not properly maintained as per the secretarial standard. Necessary approvals were not actually taken, and various things which are required to be done under Section 186 loan and investment, etc., related to that, which has not been done. All the things are brought out. In this case also, he has been penalized to the extent of 2 lakh rupees. This is what. So this all the thing raises what could actually possibly go wrong. This is what the question which came to my mind. Then I said, okay, rather than discussing what could possibly go wrong, what has really gone wrong? Let us look at that. That is what I decided. So I had gone into what has possibly gone wrong. You will see here. Gone wrong. Agenda release without adequate documents and enclosures. Disclosure made by the directors is not taken. MBP1 disclosure is made by the director. It is not taken on record by the board. Whose job it is? It is the company secretary who gets the record. He takes notes of it. He records the minutes. That is what it has happened. Not recording the date and place of the last page in the minutes. Unnumbered meetings. And again, the minutes, not initial, and even the last page is not signed. Blank pages is not scored out, etc. Full signature is not there in the last page. Again, initial is there. Minutes itself is not signed in some of the cases. Date of entry in the minutes book is not made. Draft minutes is not circulated, or rather delayed circulation of the draft minutes has taken place beyond the period which is actually specified. And at the end of the year, people realize they are not able to file the financial statement annual return because the reason is the KYC is not done actually annually, which is required to be done. Attendance register not found to have been maintained in many places. The non-constitution of board committees, audit committee, remuneration committee, CSR committee, etc. Even cases where the committees have been constituted, a wrong constitution of the board members. Adequate independent directors are not there. These sort of the things were there. And again, coming to the CSR violations, one thing, committee constitution. Second thing is disclosure in the CSR report, not as per the format specified by the regulator. And again, spending the money, if the money is not account in the specified time, all the things are out there. And again, not only that, when we talked of the MBB one, there were cases where directors have not even made those disclosures where they are required to be made. But during the related party transaction, these are all actually came out. That is one thing. And again, non-disclosure of various things which are required to be there in the board report. Significant transactions, the single standard compliances, the director responsibility statement, etc., and other things and all those things. And again, we also seen non-appointment of the internal auditor, non-appointment of the secretarial auditor. And even when the secretarial auditor is appointed, even the audit report is actually issued, but not attaching the secretarial audit report to the board report. These sort of the things also has been actually seen. And of course, the non-appointment of the independent director was there. And some of the time where the independent director has been appointed, not having the detail in the database, that is also seen actually, which has actually gone as the things. And similarly, women director non-appointment, this also. Mostly what has happened is, whenever the company get converted from the private company to the public company, there are cases like that. The multiple compliances has actually come out. Just when you are in practice, you are known well. What do you say on this? When the private company gets converted to the public company?
Yes, sir. Absolutely, sir. It's like a change in compliance structure altogether for the private company itself. As soon as they become a public company, there are multiple things that were, like you said, a typical husband-wife kind of a company, or a typical, that kind of an arrangement itself gets changed into a different gamut of compliances that get attracted.
And again, I also come across the form filing is missed out, or it is delayed, or it is overlooked. Especially beneficial ownership, which has been actually brought some years ago. People don't do the job. Beneficial ownership does not get filed, etc., and other thing and all. Those sort of the things are there. And not only that, statutory register. First of all, statutory register not maintained. Second thing is, even if the statutory register maintained, it is not updated from time to time. Entries are not being made. Chandan sir, anything you want to add?
You said absolutely correct, sir. Chandan sir, your views on it?
Uh, what actually both of you are saying actually holds good because for small companies or family-run companies, when they get go into being a public company, or even when they go into the small board for listing, there is absolutely a sea change in their compliance and the resultant uh, manpower required to man those functions. So, so it's a very difficult process actually. You can't blame the companies per se because it's not an easy thing, you know, for them to suddenly jump into the sea and get the compliances. And most of the issues which you have highlighted are again hygiene issues, which I also had touched upon because not maintaining proper records. This a company secretary at its base should be doing it. Board minutes not signed, not numbered. See, these happens because it may not be for reasons of overlooking. It could be they want to fudge the minutes to hide because I have come across many instances where they try to write the minutes without the board meeting happening, and that is where they get caught because the numbers and all those don't match. There is no continuity in the minutes. And let me tell you, a lot of cases, regulator will ask you for copies of minutes, and all those have to be certified as true copies by the company secretary, and he'll get caught. So this is something you are absolutely right. I mean, there is no justification for this. I mean, it cannot be pardoned if you are really ask me.
Yeah, I agree with you.
So
what should be the solution? The next question, okay, happen is happen, it cannot be set right. Whatever has happened is happened. How do we actually overcome it? That is the next question comes. Has happened, okay. Wherever the justifiable reason is there, as I said in the beginning, then, you can approach condonation wherever is actually possible, where, delayed compliances can be done. Those cases, yes, condonation can be actually done. You have to approach the central government. You have to get the condonation of delay done, and then we can set right the complaint. That is one way of doing it. Second way is, okay, realizing there's a mistake has happened. Okay, let us realize the mistake. Suo motu, we file a adjudication application. We approach the ROC. Oh, we have done a mistake. This is what it is, etc. We are submitting the details, etc. We request you to adjudicate the matter. That is second way of doing it. Third way, okay, do nothing. Keep quiet. Let the regulator find out. Then he takes his own course of the time. He will issue the show cause notice, and then he will follow the due law procedure, and then that can happen actually. This is another way. Then the compounding of application is altogether different matter, where the compounding is actually called for, because there are certain offences which can be compounded, certain offences which cannot be compounded. So we can do that. These are the only three things which we can actually do. To the component, maybe knowing it, since you're all already in the employment and the practice as well. So condonation of delay is actually spelled out in our framework of the law. So where, annual filing has not happened, filing could not be done in time, especially which happens with the financial statements and the MGT7 forms and the annual return forms, etc. and other things and all. Even though there are time extended period is there, even extended period also, it is not then that is also lapsed. With additional fees, you can file with the extended time, that is also lapsed. So in such a cases, what we can do is we can actually apply to the central government. The procedure is very simple. You have a board meeting, approve the application for the condonation of delay, which is to be done. You authorize a director, the company secretary, any other person to apply, and also authorize one of the practicing appreciate to appear on behalf of the company, because condonation of delay is generally done at the Delhi, where you have to appear there and it is decided and other things and all. So that can be done. Then file application. When you are actually filing the application, various documents which are required, that first and foremost thing is the resolution of the board saying that, filing the applications approved, appointing other representative. Then you have to give the justifiable reason for the delay and the relief which you actually start seeking, we should be permitted to file the delayed forms, etc. Then affidavit intervening the person. Then you have to actually send the memorandum of appearance and letter of authorization. Any other document which are called for, that is what you have to do it. Then the next thing what happens is the hearing take place. Central government will actually scrutinize the application. They will issue a partial hearing notice. On the partial hearing notice take place, then authorized person will appear. He will actually hear based on the merits, etc. Either he will accept or he will reject. On the condemnation is approved, then the necessary filing can be done. Once the filing is actually done here, in that case, then you'll have to file a form INC 28 along with the documents and necessary fees, etc. and other thing and all that can be done. So this is one thing in there. Then of course, company will file the respective document with the ROC that these things have been done. That is one thing which can be done. There's a very simple procedure, but only thing is you'll have to go through with the central government and you'll have to do that. As I said, adjudication of penalties, either suo motu application or wait, they issue the show cause notice. In both the cases, show cause notices will be issued actually, because in the nature of justice, the adjudication officer shall issue a notice saying what is the default, etc. and other things. He'll give you certain time. And of course, we are not prepared. We can seek time extension also to reply, etc., which is generally granted. Once it is done, he will issue the partial hearing notice. You appear in the partial hearing notice. Then he goes through the cases. But here what happens is ROC is actually bound by the provision of the law, because he does not have any discretionary power. Because law says what should be the penalty for the what is the offense, that is what it is actually spelled out. Only the discretion is wherever it is mentioned, not less than so much, not exceeding so much. In such a cases, yes, he has got the discretionary power. Otherwise, he goes by what is the penalty provision, which is actually mentioned in the law itself for each of the offenses. He goes by that, he issues the order. So once he issues the order, then you have an option. Either you have to comply with the order and close the chapter, or if you feel, the order is actually very harsh, etc., justice not done, etc., you have a process. You can make an appeal to the respective regional director who is having a jurisdiction over the matter. And once you actually make an appeal, then the RD will hear the appeal and he will actually decide. That's what it can be done. It can go in your favor, or he can confirm the order. Whatever it is, it can actually happen once you apply here. And once adjudication is actually done, suppose we are not prepared for the particular hearing, etc., and all this thing. If you want to seek adjudication, if you want to have additional documents, etc., yes, that also can be done. Adjudication is also possible. Adjournment is also possible for the adjudication, etc., and other thing and all. If you want to make anything, one thing is that ROC will generally spell out a reason, the rationale behind levying the penalty, because that will be actually put in writing, so that will actually help you in the application when you are file an appeal. What is went wrong? What is the thing, etc. That can be actually done. And I think in a justifiable cases, wherever the merit is there, etc., and other things and all these things, there have been relief given by the audit. That is the experience which is actually seen by looking at the various orders, even talking to the practicing people. What is your view, Jaswin, on RD appeals? Do you get a relief?
Sir, so appeals itself is like Sir Chandan sir had also said that it's a legal battle that you file. So, but of course, as and when appropriate, depending on case to case basis, if there is an appeal that is genuine, there are remedies that are provided. But while saying so, the time required and of course, it has to be a justifiable round, which goes through an entire, review, and thereafter it is considered accordingly. Chandan sir, what is your practical view on this?
One thing is there. I also seen some of the appeal matters. Appeal matters which has actually happened, they really do consider the merits, especially in the COVID time, where people could not do many things, etc. And also it was beyond the control of the company and its directors. That is one thing. Second thing is they also take into considerations of, people acting in the remote areas, people are having a financial constraints, people are actually having a, no revenue is actually being generated in the early stage of the business, etc. Various other factors they do actually consider. There are cases where the reduction is actually given in many cases, but at the same time, just for the sake of making an appeal, if you made an appeal, etc., and all this, the order has been simply confirmed. Those cases are also there. That is what I see. Yes, over to Chandan, please. You are on mute, sir.
Chandan sir, you're on
Ah,
mute. We can't hear
ah,
you.
yeah, sorry. Can you hear me now?
Yes,
Yeah,
yes.
on compounding of offenses, as I had said earlier, you should avail of it, compounding and settlement, because SEBI has settlement procedures also, which are, um, easier because it are more quasi-judicial, and you can put forth your case if there are good grounds to claim exemptions or settlements without admitting to any wrongdoing. You can do. A lot of big companies, if you check Google, you will find have gone for settlement petitions or applications. So in my view, it's a very cost saving and a less litigative process. So companies should avail until and unless it has very strong case that it can get justice. Then it should be willing to go through the entire process, because after that you go into judicial forums, whether you go to NCLT, NCLAT or SAT, and then you go to the Supreme Court. So, you should be willing to fight it out across the gamut. So that is my understanding. So, but and if your grounds and there are many. That's why I said, as a company secretary, you should read the cases. It's very good that Bala sir is talking about all these cases. They have a lot of relevance, because when I talked about legal research, you have to go through hundreds of cases which are relevant, because you can't just quote a citation without understanding, just the heck of it. There are cases where wrong citations have been given and the court has hauled you up, or it has used it against you. So you can't just take a para here and do cherry picking, and just because you want to show it as a legal document, you mention cases. So you have to go through the entire case history, the orders, the relevant provisions, and because every case is different. So just a word here and there will not make it an important case. They're reportable judgments. So it's a lot of work. If you want your compounding and settlements to be done, then your case has to be very strong for you to really do it. Or if you have to appeal against an order. So your legal research and your briefing skills, because you need to have a case diary and create briefs, because you're equivalent to a lawyer. Because let me tell you, as a company secretary, it is very important, very, very important that you are present. You may not be arguing the matter, but you should be there with the standing counsel, with the arguing counsel. Like in Bombay, you have the barrister and lawyer concepts, where the barrister is actually arguing. In other courts, we don't have this. Like in Delhi, we don't have this kind of concept, but you should be able to be with the lawyer, stand with him, and even provide clarifications or with notes if he needs, for him to argue properly. So, which means they should know about court decorums. You should know about, and I have personally felt sometimes the lawyer is appearing somewhere else and the court calls you even for a passover, because lawyers have multiple cases. They are in some other court and your matter is called up. What will you do? And the judge might ask you, or the bench might ask you, that can you explain, please, as a authorized representative AR of the company. So you should be ready and explain, and then seek a passover. Say that my lawyer is on the way, or is in arguing, he's in some other court, and hence give me a passover. So, so all these are very important. And compounding of offences, as Bala sir said, is a good option.
And that's one thing is there, as you really well said. You have to justify your matter. That is very, very important. Because very recently I came across some order. He has appealed for the appeal. The argument was what? Argument was he actually brought out some of the orders passed by the different ROCs, more or less in the similar matter, where the reduced penalty has been actually levied. So he said, because other ROCs have taken this stand, they given the reduction, the things you should give me a reduction in this particular case. That was the argument. This particular RD said very categorically, sorry, that the ROC has taken a call, he has decided on his own. What is the merit in your case? You please tell us. Then I'll decide. Based on some other ROC has given the reduction, that does not give any justification for making your case to reduce the penalty. That is what it has come. And ultimately, he could not justify, and he simply confirmed the order what is issued by the ROC in this particular case. You are rightly touched upon the case, because when we go for argument of the case, we should go fully prepared by doing our homework. We should be able to justify, we should bring the merits, we should seek what is the relief, what we actually need, rather than just quoting the cases, etc. You have well said actually here. I just came across only some 2-3 days back. Some practicing company secretary has brought out some orders on order. He said, you see, look here, this ROC has done this ROC, this is the reduction, this is the reduction. You should give me a reduction. This is what it has actually happened.
Sir, you are absolutely right. Uh, our courts follow the precedents, like high courts follow Supreme Court judgments, and that follows as it is. But even if you see order passed by the Madras High Court need not be taken up by the Delhi High Court, because when we argue matter in Delhi High Court, we generally will give orders passed by the Delhi High Court or the Supreme Court or the apex court. So just quoting doesn't make it look very nice, because if you have quoted a wrong order, and as you rightly said, sir, or the RD also, just because you have said this cannot be a ground for seeking reduction. Yeah, it can help your case. It helps, it buttresses your case in the sense is that, yes, there is a precedent, and ROC in a similar matter, similar grounds, has given a reduction, and we may be also allowed to take that benefit. It's only a pleading, it's only a prayer. It is not a etched in stone that says that because this happened, I also get the same benefit. So it doesn't work like that. And no regulator will accept just because if it's a own regulator's orders on a similar ground. Let me again emphasize, the grounds have to be similar. they cannot be, just by, as I said, giving a citation will not absolve you of your responsibilities. So
Absolutely
again,
correct. Absolutely correct. As you rightly say, Madras judgment is not bound the Bombay court judgment. Because he will say, okay, it's all right, but I am not bound by that particular judgment because the different jurisdiction. He might say, because there is nothing is like that. Only
no,
the
sir.
Supreme Court judgment is binding for all.
Sir,
Of course.
sorry. No, sir, what
Of course.
happens?
Yeah.
Sorry. When it comes to high courts, why it is not so is because they are parallel courts. They are
Correct.
not subservient to each other.
Correct.
So, no, because they are two parallel courts, they cannot take. But if you are a superior court, then the inferior court is bound by a superior court judgment.
Yeah,
But
that is
again,
right.
sir, that's a technicality. But if you look at it, your case has to justify that citation.
Yeah, that is right. As you rightly say, you use the
That's the
word.
most important part. Yeah, it has to be relevant for that particular case itself.
Yeah, relevant things, similar case, similar grounds, those things are there. Yes, you can. That is the issue. Yeah. Anyway, moving forward, Mr. Chandan has actually touched upon many things because this is one of the options. But only thing is, as you are aware, what can be compounded, what cannot be compounded. That is very clear actually. Only the fine and imprisonment, either this or that, then only it can be compounded. If it is only imprisonment, that cannot be actually compounded. Again, compounding, there are different authorities there. Up to 25 lakh rupees, it goes to the regional director. Beyond that, it actually goes to the NCLT. This is again the procedural law thing which is actually there. Most of the things have come to the adjudication. Compounding is actually not that much, things are getting today because most of the things are all going through with the adjudication here, etc. But only thing is there are certain things are there punishable with the imprisonment cannot be actually compounded. And again, any investigation, etc., is actually initiated against the company, then again, you cannot go for the compounding. And again, there's a limitation is there. If the compounding is done for a particular offense under the particular section for the 3 consecutive years, you cannot actually go for the compounding efforts. When you say offense, it should be the same section. That is the case. Anything which is there, you cannot go for the 3 years. That limitation is also there. Then again, the same like any other thing, you need to have the board meeting, you need to have the approval from the board. And again, when you talk about the board, again, we are again coming to the compliance, complying with the SS1 standard, which is giving the necessary notice, etc., following the procedure, etc. Board pass the resolution. Then thereafter, you prepare the compounding applications. And the compounding application has to go as per the specified format given by the NCLT. NCLT rules are actually specifying it, so you have to go by that. But all the thing is to be done on the online. You have to file with the GNL one form compounding application. It has to be submitted electronically to the concerned ROC, and the physical copy is to be lodged actually. Then the document which will be called for the compounding will be detailed petition and affidavit verifying the petition, memorandum of appearance or wakalatnama, whatever it is, and the board certified copy of the board resolutions, then authority to whom the authority is given, etc. Then evidence. Normally, the evidence in the sense, whatever the show cause notices, any other things which is issued, etc., that will actually come, any other relevant document. These are all the things which are required to be done. And I think most of the things is required to be notarized in the application. That is what it is to be done. Then once a compounding application, who can actually file the compounding application? In a private companies, as we have seen, the company secretary maybe there, may not be there. In such a cases, director, or if the company is run only by the non-executive director and the concerned manager, any authorized person, they can actually file. But only thing is, if you are a director, then you need to have the DIN number. In other cases, it will be a PAN number, etc. The proof will be required. If PAN is not the non-executive, the director of expatriate is there, then the passport will be actually called for as a proof, etc. That is what it is there actually. And foreign company, of course, they can appoint the authorized representative to file the compounding applications. And again, DSC is only for the director. The people who are not having a DSC, they can actually go practicing people like CS, CA, ICW, etc., they'll have to go by PAN number. That is what it is required. Then, of course, the personal hearing notice will be issued, either is RD or NCLT or whatever it is, you'll have to say. Then once you make your stance, etc., they will issue the speaking order. They will actually spell out what is the rationale behind issuing the order, etc., and other thing and all, whatever the penalty levied, then that has to be paid. Then again, you'll have to comply with INC 28 form filing and intimate to the ROC. That is what it has actually happened here, the compounding which can be done. Into some of the orders, because as I said very clearly, nowadays SEBI is also taking up the matter, and they are actually coming out very heavily for the non-compliances nowadays. So these are all some of the orders which has recently. The SEBI passed out the order on the insider trading actually. In fact, a non-closure of the trading window at the time of the unpublished price sensitive information was there. This was one of the cases where the SEBI actually penalized the company secretary to the tune of about, initially it was fined by the SEBI 5 lakh rupees, but of course the appeal was made. In the appeal set actually said, okay, the non-compliance is there, but it is not considering the severance, etc. They reduce the penalty to 5 lakh rupees to 1 lakh. This is what it has actually happened in this particular case. There was another case was there. In the another case, what has happened was, this was a company secretary, and she has been actually penalized 50,000 rupees penalty by the SEBI. The appeal was actually made. This case is a little slightly a different case. What has happened in this particular case? The company secretary actually resigned. As you know, normally, whenever anybody resigns from the job, company may not involve him in the day-to-day work, etc. He will be asked to, involved in the handing over procedure, etc. and other thing and all. That is what they will do. In this particular case, although the same thing was happened, a company secretary was not actually actively involved in the day-to-day affair. He was actually not even part of the board meeting, etc. and other things and all those things. So she made this girl actually, Pooja Naina. She made the representation the appeal. Then SAT actually appreciated whatever she said. She said she is no way involved in this particular matter. She is kept out of touch from the routine things, in which case she is not responsible at all. That is the thing one has happened. And second thing is what has done SAT. SAT not only reversed the order, SAT has actually ordered the company to pay 50,000 rupees to her because of her harassment and the litigation cost, etc. and other thing and all. That is what has happened in the second case. Then there's another case which is actually there. It is actually by SEBI. SEBI actually levied 5 lakh rupees penalty in a Satyam computer for not closing the trading window. Again, the same issue of UPSI. And the SAT actually confirmed this order to the tune of 5 lakh rupees, saying that it is the duty of the company secretary. Company secretary has actually failed to do it. It is the company secretary. Again, the recognition of the company secretary focuses in this particular case. Then again, we have some buyback issues. In the buyback issue, the question actually arises whether in the case of the buyback issues, whether company secretary is responsible is one case. What do you think? Company secretary is responsible for the disclosure made in the buyback document? Parveen? Sorry, Jaswin?
Yes, sir. Any kind of disclosure made on behalf of the company, especially related to the matters where the CS is involved. Not, we can't make a generic view of it, but definitely related to ones related to compliance per se, then the CS would be applicable.
Yeah, let us look into the cases. One is like the related party transactions. One of the case in the related party transactions, what has done is related party transaction non-compliance was SEBI actually penalized 25 lakh rupees because there was a improper approval was taken from the audit committee. That was the issue actually in this particular case. Then ultimately company went to appeal. In the appeal, they actually considering the appeal, the 25 lakh rupees have been actually reversed to 10 lakh rupees, but still the violation is there. It is required to be published. Only the question of quantum of the penalty has been done in this particular case. And there was another case. It is actually pertaining to the company secretary of Deccan Chronicle Holdings here. So here what happened, it is actually a accuracy of the financial disclosure in the case of the buyback. This is the issue here. So here what has happened is, here initially the company secretary was actually paralleled by the SEBI. Matter went to the SAT. SAT actually going through the issues, they actually said it is actually the fiduciary relationship with the directors who are actually supposed to make the statement, where the CS actually authenticating what has been actually transferred, what is that, per se it is the duty of the directors. That is what it has actually happened. They reversed the judgment in this particular case. This is what it happened. There was yet another case there, another case more or less on the similar issue, but this belonged to 1956 Act, which may not actually hold good today's circumstances because there is a sea change which has taken place between 1956 to 2013 Act in the role of the
Absolutely, sir.
company secretary. So this
Right.
may not be really relevant because what happens, CS is now designated KMP, which was not the case in 1956 Act. And now today CS is actually ranked pari passu with the managing director and CFO, CEO of the company here. So definitely here what happens is CS is actually mandated under 2013 Act to ensure compliances that are applicable for the company under all the applicable acts. That is what it says, not only under the Companies Act. In which case CS cannot actually overlook this responsibility in this particular case. Although in 1956 case this matter was actually there, still the matter actually went to Supreme Court actually. I think the decision is still pending. To the best of my knowledge, the matter has not been actually resolved. I have not come across here. The matter is actually pending with the Supreme Court on this particular issue for the discussion. But anyway, I definitely feel the role has changed much between 2013 and 1956 Act. So we have to actually ensure compliance with all the applicable laws, not only the Secretariat Act. That's what it is there. Praveen, you will be also doing the things in your practice, etc., and other thing and all when you are coming out with the things. You can add something.
Absolutely, absolutely agree with you, Agan.
And then there was a LODR regulations. Multiple non-compliances happen in this particular case actually. The multiple non-compliances which happen, you can see actually shareholding pattern has not been complied with, financial results are not complied with, corporate governance report was not complied with, annual report is not complied with. Then adequate steps have not been taken for the addressing the investors' compliances and regarding the non. And even the composition of the board, appointment of the women directors not happened, council of the audit committee has not taken place, council of the nomination remuneration committee has not taken place. All the things have taken, multiple non-compliance have taken place in LODR. So in this particular case, they have been actually penalized about 3,68,000 rupees in this particular case for the non-compliances. Appointment of the qualified compliance officer was not there. These things also happened. So here the matter went to actually SAT. They have appealed because the fine and penalty was to the tune of about 20 lakh rupees for the multiple things, but they went on appeal. But the SAT has actually gone through the case and as Chandra sir put it, they could not justify the merits of the case. So nothing, SAT has simply dismissed the appeal. They actually confirmed, sorry, nothing. We don't want to interfere the order. You pay the penalty and other thing and all because none of the carve out can take out on this particular matter. Non-compliance or non-compliance, that is what it has actually happened. The point is, regulator are now looking very seriously the non-compliances and the governance related issue. So we need to be more careful. That is what it is actually coming out.
Question in the chat box. So one of the participants has said, "Sir, where can we file appeal against the order passed by the RD? There should be a mechanism to allow appeal before NCLT. Like we can file appeal against orders passed by the Commissioner of Income Tax before the ITAT. At present, there is no judicial member in the entire hearing process, and they are employees of MCA, and therefore most of the orders are in favor of MCA only." Chandan sir, your views on this?
See, against an order of RD, it is under the Companies Act. So the process is to go to NCLT. Because you cannot go to the High Court because you already have an appeal forum available, so High Court will not take it up.
Right. We have a quasi-judicial body already.
No, we have an appeal body. When you
Right.
have a forum, when you have an appeal forum already available, the courts, until and unless it is vacant, if the bench is vacant, which is not the case with the NCLT. Company petitions are there happening, every day. I mean, in Delhi, it is every Thursday, once a week. So you will challenge the order before the NCLT and then go to NCLAT and then go to Supreme Court. So there are forums available.
Let us look into the adjudication order passed by the ROC. As I was telling you, these are all the trivial issues which is actually happening. DR12 is not filed. KAC is non-compliant, that is why they could not file the form. Unfortunately, in this particular company, there is no company secretary is there. So company has been penalized 50,000 rupees and each of the director, 4 directors were there, 10,000 rupees each. The past directors were also present during the course. So they have been also paid 10,000 rupees. That is what it has happened in this particular case. In the second case, if you see, the distinct minutes book not maintained for the meetings. That means non-compliance of SS1 non-compliance which has happened. Company and directors were actually penalized in this particular case. The question is probably, I think it comes to my mind, do the directors are actually aware this is what it is required to be done? That is the question. Because if I ask some of the private companies people, how many people are actually aware about the presence of the SS1, SS2, the compliances, etc.? I don't know. Chandan sir, you think directors are aware about SS1 and SS2 presence?
Sir, it is like this. When you release the board pack for any meeting, what I do is, it might become slightly voluminous, but whether board or any committees, if there are any matters where a board has to take a call, so it is always better to give a gist of the provisions, and any reference to the secretarial standards. For example, as a normal course, the draft minutes have to be circulated within 7 days of the board meeting. And there is a provision that if a director does not reply to it, you can, then the meetings are taken, then the draft minutes are taken as approved. So it is better to, when you circulate, you give that. You tell the director that this is the provision. Don't teach him, but give him the provision. So that if the director first becomes aware that he has to give his views within that stated period, if he does it, then he accepts that whatever the draft minutes have been shared are what actually transpired in the meeting. So tomorrow, if it is questioned and the minutes are called for, the company secretary can show this documents and say that he has done what he's supposed to be doing. He has recorded the minutes and he has circulated it. And the directors have not replied. And it is deemed to have been accepted that it is the actual true recordings of the board. Even if you don't do a VC meeting, I'm talking about physical VC meetings, so obviously you have recordings of the VC meetings.
Absolutely, I agree with you, Chandan sir. In fact, really speaking, I am also saying the awareness should be created to them. Not that we are going to teach them or something like that, because ultimately the compliance is to be done by the company secretary or whoever is actually there. But the thing is, the awareness should be there, because the approval or not approval is rest with them actually. Within 7 days, they have to come back, or they choose not to come back and they nothing. So that awareness is to be created, which you are actually doing wonderfully. That is what I'm also talking about that. Because many of the things are not known. That is why it goes rather unnoticed, the things are happening like that.
Sir, even for a CS like us, we cannot be knowing every provision, every circular which is being released every day. And India has maybe 3,000-4,000 laws. Now, even for me, if you ask me suddenly that, what is section 120? I may not remember because, I am doing things practically. So even for me, it will be very difficult if somebody asks me, sir, what is this? I have to also look at the provision. I have to also see, is there any circular, anything which has any amendments, and then take a call. Because as legal professionals, we cannot just go and say something in a haphazard manner, especially to a board. You have to be very certain of what you are saying, because based on what you say, the board will take a call. If you give them wrong advice or you give them ill advice, then the board will be at fault. And your credibility as a company secretary, and it is very important. See, in the board, my understanding is bigger boards, professional boards, you will have different types of directors. You will have professional or advocates also. Might even have company secretaries also. So once the board understands that you are, as a professional, you are very strong in your understanding of law and your advice to the board, then board will start depending on you quite a bit. They will accept whatever you give with seriousness. If there are mistakes in what you write, if you are in a haphazard manner, lackadaisical manner, then the board will lose credibility in you. They will not know whether you can be trusted upon. You take time, because in board meetings, what happens is suddenly an issue comes up. Some directors asks a question which he would have understood from some other meeting he has sat in. Because most of these directors, professional directors, sit in multiple boards. Now, you may not have a ready answer. So you should be capable enough to tell the board that this is a matter which has come to me now. Give me some time. I will circulate a note on this. The board will accept, because they know that you cannot open the Companies Act or open a citation and start reading there. So you circulate a separate note to the matter which has been raised, covering everything. And in the next board meeting or committee meeting, ensure that that comes on record, so that there is a process.
100% you are right, actually, Chandan sir. One thing is there. Even any company secretary for that matter, because when we talk, there are about 475 sections are there in the Companies Act. Everybody will not remember all the sections. But only thing is routinely what we are handling very regularly in the every board meeting, which is actually coming up. Like, director appointment, director remuneration, related party transaction, all this sort of the thing, if you ask, definitely everybody will remember. If you ask what is section 197, 198, 184, 186, people will immediately remember because they have been handling it regularly. As you rightly said, somebody suddenly asks some section which you are not regularly handling it. Unless you do your homework, it is not possible. You are absolutely right. Only thing is, we should be responsive enough to tell them, okay, look here, it needs some time for me to go to the detail and coming back, and I'll come back. I'll come back within the reasonable time. That is what we need to do. Even it happens with the practicing people as well, actually. Because practicing people also will be dealing with the things which they are actually routinely handling it. Any non-routine matter has come, they'll have to actually do their homework. Isn't it?
Absolutely, sir. Yeah, absolutely. And it's always like sir says, it's always better to candidly tell them that we need time to get back to you on that, rather than just giving an incorrect opinion on a certain matter. So that's absolutely correct.
So again, I come across with the unnumbered meeting and the unsigned minutes and no meeting serial number and minutes books, etc. These all the things happening because the reason is probably it is awareness is not there. If awareness is there, then all these things would not have actually taken place. That is the issue here, because the company secretary is not there. If the company secretary is there, you would have taken care of. Company secretary is not there. The people who are there, they come for the meeting, they attend the meeting, and it is assigned to somebody. This is what it has actually happened. That is what I'd say. These are all coming in the private companies cases. Cases here, you can actually see here from here itself. Minutes book not consecutively numbered each page. In fact, I come across in some of the organizations, what happens is the minutes book numbering is assigned to a person who's actually working in office, the lower level person, is a book or number kar do. We don't even actually look at that, whether it is consecutively numbered. Just to going through the pages, we can see whether it is consecutively numbered or not. Any mistake has happened, that can be taken. That check is actually missing. It is all right. You can delegate the job. But the thing is, again, the question of that maker checker, whether things are signed, done correctly or not. Somebody has to check there. That is one thing. In fact, I have come across one of the case, Jaswin, the numbering has been done by pencil. They have taken the issue, very trivial issue. They have taken the issue. They told by doing the numbering by pencil, it can be altered because it should be done intelligible pen ink. So it is not acceptable. Show cause notice has been issued. So these sort of things which are actually happening. So somebody has to actually ensure here, again, the minutes book not consecutively numbered, minutes book not initialed, and again, last page is not signed. This is what it has happened. And again, non-circulation of the draft minutes which has happened, delayed circulation of the draft minutes also has happened. In these cases also, see the amount of the penalties which is actually there to the tune of closer to 1.90 lakh rupees for the simple non-circulations. If they know these are all required to be circulated, nowadays with the digitalization, etc., and all the same, just only one mail, marking a copy and CC to all the people together, one mail would have served the purpose here, which has actually not taken place here. And the unfortunate thing is, in this particular case, company secretary's presence is there. This is the thing. In this
Hence,
particular
the process
case,
of sir audit as well as due diligence that is carried out has become even more important because, like you correctly said, there has to be a maker and a checker to ensure that it is 100%, in place, all the records.
yeah, that is right. See, everybody has to evolve their own mechanism. Either you can have a checklist, work with the checklist, check yourself. That is one thing. Or you can have the maker-checker principle, that you can do one thing. Or you can have a to-do list. Okay, before the board meeting, during the board meeting, after the board meeting, what is to be done, what is to be ensured, this sort of thing. It has to be ensured by people who are actually doing this, either company secretary or authorized person, whosoever it is. That sort of the thing should be there, then only things will work. Otherwise, these sort of things, these are all, if I look at it, is a very, very trivial things. What Chandan sir puts in hygienic issues, which is not really taking place. Let us look into some of the public companies where really. Now, as I said initially, when the private company gets converted into the public companies, then what happens? There are now some of the was a private company. This company has actually got converted a public company. When the company got converted to the public company, after getting converted to the public company, then it called for actually they have to appoint a independent director. That was the requirement is there. Required to constitute audit committee, nomination committee, remuneration committee, and they are also governed by the CSR committee and the specified number of independent directors. All the things I actually missed out in this particular case. So they have not done it. Each of the non-compliances, the penalty, because unfortunate part is company secretary was there actually in this country. See the amount of the penalty which has been actually levied. Company 3 lakh, MD and 4 directors 1 lakh each, 5 lakhs. Company secretary, current secretary 51,000, past company secretary 1 lakh rupees. This was the independent director non-appointment. Now, non-constituents of each of the committee, audit committee and the nomination, the remuneration committee, in both the cases, 12 lakhs. So again, all the directors, including company secretary and the past company secretary. CSR committee, same thing. Here also the company secretary, past company secretary. So all the thing which is emanated to something about closer to 38.65 lakh rupees is the penalty amount which has happened because the private company converted to the public company, things are not taken care of. The real thing is, when you actually convert a private company to the public company, first thing you'll have to see what are the things which are required. You should work with the checklist. These all the things could have been avoided, isn't it? Then again, there are another case where there is a multiple non-compliances which has actually taken place here. There multiple non-compliances. If you register office is not maintained, how the register office is not maintained? Because they sent a notices, etc. It was not received. Because regional office means the register office should be capable of receiving the communication. That is the first and foremost thing, which has not happened. They actually visited and nobody was there actually in the register office. They have come to the computer, register office is not maintained. Then again, statutory register not maintained. The non-maintenance of board and AGM minutes, postal ballots, etc. And even default of not conducting the meeting, annual return is not submitted, financial not submitted. All the things which has actually happened in this particular case, multiple non-compliances. Then here the disclosure, yeah.
Sorry. One thing I just want to, I was seeing the chat. I just want to clarify. I think, when I talked about the circulation of draft minutes, see, you have 15 days time to prepare the draft minutes, and the directors have 7 days time to confirm it, or the silence is deemed to be confirmed. So I just want to correct it. If I have said 7 days, actually, 15 days is the time for you to prepare and circulate the, preparation of draft minutes, because preparation of draft minutes takes time, because it is, you can say, roughly 99% of the minutes, because you don't do draft and then, start making the actual minutes very different to the draft, because after that you will again circulate the signed minutes. So you have to ensure that it speaks the same. Otherwise, the draft will say something and the actual will say something. So I just want to, if there is clarify it. It is 15 and 7.
Yeah, you're absolutely right. Because 15 days for the circulation of the draft minutes, and 7 days is confirm or not confirming it, that is there. Once that is there, then the minutes are actually deemed to have been confirmed actually. But the actual signing takes place only in the subsequent board meeting. And after the minutes are signed, again the same thing is actually circulated to the people. I think that is the right procedure, as you rightly said here. But in this
Also,
particular,
adding on to your previous slide where you mentioned that there was penalty for non-service, non-maintaining of registered office. So I just wanted to add on that actually the Registrar of Companies has been taking this very seriously of maintenance of registered office. Even post incorporation, any company has to show with photographs the the registered office address with all the details relating to the company, including the SIN number mentioned and the name of the company mentioned, along to the extent that where they've asked that one of the directors should also be sitting in the office. So that proof is also to be furnished. So this is a point that is changed and evolved over a period of time and is being taken very sincerely and seriously by the Registrar of Companies.
yeah, absolutely, you're right actually, because the requirement is now, it is not only taking the photograph has to be taken in such a way, the latitude and longitude should appear on the photograph. That
Absolutely.
means showing where is the location of the office is there, that should appear, that is number one. Number two is there, in fact, there are two photographs is required to be attached. So one is the photograph is the outside main building where the office is there. And second thing is there inside, showing the nameplate of the company, which is actually engraved and put it very clearly, showing the register office, address, SIN number, the telephone number, contact number, etc. Everything. These both the things should be there so that you show the existence. That is another thing. And one more thing, when you rightly said, even when the communication has not been received by the people, ROC actually took a trouble of deputing somebody to visit the place whether really there is a register office in existence or not. When they visited the place, they could not find the nameplate also of the register office of the company. And ultimately, the inquiry revealed the namesake they are maintaining the register office, there is somebody else's office where they have taken it on a rent, saying that this is our register office, that is all, and nobody was there. So that means, maintaining the register office for the namesake is not going to be workable. That is the thing. Of course, many people in practice, it happens like that, but once they find out, you pay the heavy penalty. In fact, I remember I was working in one of the company where we had a rented office from one of the renowned lawyers' office, actually, the prime location at Bombay. When we actually told, this is the requirement is there actually, we want to take a photograph, we want to put etc. and other thing and all. She said, you have taken the office on the rent, but your man comes only 2 days in the office. Otherwise, my man is only keeping on receiving the things, etc. and all this thing. The condition is that you should be there here. When you are not there, sorry, I don't want to give this premises for your rent. Unless you put a person continuously sitting here for all the 5 days. Then only you take it on rent. Otherwise, you don't take it on and terminate the rental service. I don't want to get into this sort of thing. That is what she told very categorically. Because taking a office is okay, but nobody is present. The very essence of, the company is capable of receiving the communication. That is actually being the crux of the matter in this case, which is very important here.
Right. On the chat, which from one of the participants, so it says certified copies of signed board meeting minutes are again to be circulated to all the directors. Many companies are not doing this and are taking it lightly. Has any company been prosecuted for this lapse?
I don't think I'll have to check up this particular case. So far, I have not seen it, but definitely I'll run a check. But it is a non-compliant, but there is a provision is there in the law, if I'm not mistaken. If the company is actually resolves in the matter, what the draft circulation is actually made, the final circulation need not be circulated like that if they resolve in the board meeting. I think there is an exemption is available. I think one of the circular in the past. I think probably that you can refer. So if that sort of things are there, then in such a case, circulation may not be called for, but it should be resolved in the board meeting agreed by all the directors. That's what I think. Because as Chandan sir puts it, the draft circulation is nothing but almost the final circulation only. It is only question of signed. Because the draft circulation is actually unsigned. Okay, even if the draft circulation is done, if the people are come back, again what we do, revise the minutes, we circulate it again. This is the right one. So that is what the final circulation is there. Yeah. Chandan sir, your view on this? Not circulation of the
Final minutes.
Yeah.
Sir, again, irrespective of what the provision says of the directors or majority, they say that we don't want the final minutes, copy of the final minutes. But that doesn't help because tomorrow if there is any issues or who is liable, because now the directors and the KMPs sit in roughly the same parallel as far as compliances go. Then it will be very difficult for you have to prove that the draft minutes were actually the final minutes.
Yes, absolutely.
That is a big issue. Secondly, directors come and go. As he said, some directors might dissent. Okay, then how do you record those dissents? He might have said something, you might have recorded something, and it also happens. Again, very practically, I'm telling you, in a board meeting in which all this were happening, the next board meetings, the person who chaired that board meeting was not chairing the next board meeting. So the chairman of that board meeting signed the earlier minutes, under this thing that he's signing it. Now he may not have been present. So there are a lot of complications in this. And I don't understand why would directors not want the final minutes? I mean, what is there so secretive about it or so much cumbersome? They are only getting a soft copy, signed minutes, or certified copies of some resolutions. So per se, I have not come across cases where directors give you such blanket approvals that, don't send us anything. It will still make them.
Go ahead.
It will still make them liable. So it is better to have the minutes and be very sure that this is what was discussed, because in physical meetings, I'm telling you. In VCs, we don't. If they ask for the video recordings, we can give them, but generally they don't ask because the minutes are sufficient.
In my view, the signed minutes are required to be circulated because, as Chandan sir puts it, tomorrow something goes wrong with one of the directors' issue, he wants to represent and other thing and all, he has got the document in his hand. Otherwise, unnecessarily, he has to run through the company again. We'll have to ask for the documents, post documents, getting the things and other things and all those things. That is actually going to be time consuming. It is going to be a very difficult, etc. and all those things. To be very frank, the finally signed minutes should be circulated to the directors, and the directors should actually preserve it and keep it in case if it is required in the future for references, etc. Because ultimately, the signed minutes of the company is actually going to serve in the evidence in the court of law. So naturally,
Absolutely.
that should be done. That's what my view is there. And then there is a private placement. In this particular case, in the private placement case, what has happened is they have actually utilized a public platform where the number of circulations, etc., and all the things participants were exceeded because they decided to go by digital. There was one of the organizations called the Plentify Capital Limited, which has actually happened in that case. So in such a case, the violation has actually detected is enormously. If you see the amount of the penalty, 2 crores each. Maximum penalty has been levied. Company got 2 crores. Chief Executive Officer 2 crores. Not only that, even the independent director, because they are party to it. Because anything which is followed in the board process where they have actually consented in such a case, they cannot escape from their liability. In this case, the company has to sell off almost about 7 crore rupees in this particular case, which is what it has actually happened. And again, in another company, non-appointment of the secretarial auditor for a period of 6 years consecutively. This is what it has happened. So each year, it's a penalty is about 2 lakh rupees. So 2 lakhs multiplied by 3, 6 lakhs, 3 people. This is what has happened. 6 into 6, 36 lakh rupees is the penalty. They'll have to pay for it. That is what it has happened in this particular case. Let us look into specifically certain areas. As I said initially, what we'll do is we'll just look into, because I'm just going to take to you some of the cases in the secretarial areas and something related to annual return, financial return, and then something related to the directors and filing, etc. We'll see in the category wise. That is what I have done, which will be helpful to you. What happened, what we are missing it. Filing the commencement certificate. This is another thing which has actually happened in one of the case. And it attracts the company and all the directors. And again, non-maintenance of the registered office. Again, we talked enough on the non-maintenance of the registered office. And again, what happened? Not mentioning the address of the registered office, SIN number, and the letterhead of the company. That does attract the penalty for people. This is what it has happened in this particular case. Because if we actually go through section 12, which is relating to the register office, the documents, etc., and that spells out what is required to be made, what is there, the thorough checklist is to be prepared. So which is actually there, which has happened in this particular case. In come to not sending the proper notices, that means again SSO non-compliances, which has actually happened. And the notice issued AGM without financial, without audit report, that is without enclosures, which has been assessed to non-compliances, which has happened in this particular case. And again, disclosure is not made. That means the explanatory statement where the independent director was appointed, the details of the independent director, etc., the disclosure was not made in this particular case. So in this case, if you actually look at it, the past company secretary was also involved. He is also penalized in this case because he was present at the non-compliance time. And coming to the board meeting, it is basically relating to the disclosure requirements. Number one is not holding the board meeting within the gap of 120 days, which has actually happened, non-compliance of SSO in this particular case, which has happened here. Here again, the company and the here the 2 KMPs were there in the company, that is CS and CFO, both were there. Both of them were also penalized, actually, both the KMPs, which is actually there. And similarly, in another case, the same thing which has happened where the ex-directors were there, company secretary was not there, so ex-directors and the current director, they were actually penalized. Then the blank pages is not signed by the chairman. It is not scored out, it is not signed by the chairman. Again, the SS on non-compliances, which was actually there. Here again, the KMP, that is CSO, CS and CFO, along with the company and the director, they have actually penalized on this particular matter. Purchase of the vehicle by the company not been recorded. Details of the advance or loan given to the various group parties have not been recorded. Details of remuneration of director approved by the board has not been actually recorded. Details of the employees again the company had not been approved by the board. Loan borrowed from the banks and other parties has not been recorded. Details of the collection of the funds to the private placement from the farmers not recorded. See, all the things which are actually to be done routinely in the board meeting, approval, etc., which is actually not done. This is what it has actually happened in this case. He actually spelled out in this order. It is a speaking order. What they could have done, what they have not done actually. This is what it has happened in this particular case. And then we go to the board. I say actually nothing but it is a progress report. It is a progress report of the company. Because every year, like we get in the school days, we used to get the progress report every year. At the end of the year, we get the report, annual report, progress report. In our time, there was a quarterly report used to be there. I don't know now whether it is quarterly there or not. Maybe in some of the schools having the term report. So they talk about what is the student, what is the attendance, what are the subject, what they have scored, what is the thing, other activities, all those things. Similarly, board report is nothing but it is the progress report of a company for the last 1 year, what has happened. You have given the delegate authority to us. This is what we have done. This is what the revenue. This is what the expenses. This is what the profit we have generated, loss we have incurred, etc. And other thing and all. These are the various activities. These are the things which has happened throughout the year. That is what actually a progress report. So there are various disclosure is required to be made. In fact, as I said, our institute has also brought out a very guidance note on the board report. What are the items, etc. is to be covered. Even the Companies Act also spells out very categorically. All those things are all there. With all those certain attachment, secretarial audit report. The question is, secretarial audit report has been actually issued, but it is not attached to the board report. This is what it has happened in this particular case. And then material events not disclosed in the board report. Here, if you actually look at it, the fine is not only the directors, it is actually coming on the KMPs as well. And the KMP, in this case, CS and CFO, both are actually there in this particular case. This is what it has happened. Then again, incorrect director responsibility statement. That also featured, that is also attracted the penalty. The board report is there actually, but unsigned annexures were there. Okay, everything is done, but it is not signed. That is what it has happened. Then there was a disclosure of unapproved related party transaction. Related party transaction has taken place, but it was actually not approved by the audit committee. But in the board report, it is actually featuring. That is what it has actually happened. Then there is the auditor's qualification. As you know, auditor's qualifications are required to be addressed in the board meeting. What are the things, reasoning, what are the corrective actions, etc., which has not been done there. So there also, this penalty has been attracted. Then again, incorrect disclosures, because subsidiary company was there actually, but subsidiary company disclosure were actually not given in the board report. So they could refer from the financial statements. So that is what has happened in this particular case. Then in case of the CSR details, the CSR details, it attracted, as you know, CSR details, if you are not given, etc., is a non-compliance, it's a very heavy. For the companies, it is actually very heavier. But other individual director is a 1/10. So that is what it has happened. In this particular case also, the CSR non-compliances, which has been actually attracted, which has happened here. Then again, another issue is there annexed to the board report. Normally they give you, what you call the employee detail, technical observation, foreign exchange, etc. and other thing and all. In this particular case, the energy consumption and the technical observation and the forex earnings were not given. Board report. So that has attracted the penalty here. Non-disclosure of the DIN number. This I come across many a time actually. Any communication which is going to the regulator, it has to be bearing the DIN number. Even when the company secretary is there, company secretary membership number is actually required. Even his address is also required to be there. There's a circular has been issued by the regulator. If it is not following it, then it is the case. In this particular case, see the non-mentioning the DIN number attracted almost about 6.5 lakh rupees penalty. This is what has happened. There were 3 directors were there. So it has approved. It is a thing, but of course they went to appeal. They got it reduced. So they considered, okay, considering the company size and other things, etc. and all, they reduced 650 to 60,000 rupees, the appeal. As I said, in appeal, based on the merit, things can happen. This is one of such cases where it has happened. Initial penalty was 6.5 lakh rupees, and finally it got reduced to 60 in the appeal actually. Then again, the board report did not, correct the internal complaints committee under the Post Act. That is another thing which has happened. It should be very careful because it's looked very, very severely nowadays. Because here, MD, CFO, CS, all these people were actually penalized because non-conscious of the internal complaints committee under the Post Act, which has actually. Now, let us look into some of the financial statement annual reports defaults. Delayed filing attracted the penalty. The query is, even if you file the delayed filing, all right, but it does not mean there's a non-compliance there. Intervening period, whatever the non-compliance there, that get attracted penalty. In this particular case, that is what it has happened. Delayed filing of the financial statement, which has actually happened. You can see here. But at the same time, there's another case. Delayed filing has been done, but the thing is, there is no penalty has been levied because there is a circular has been issued in respect of the annual financial statements and also annual report. If the company has filed the filing before the issue of the show cause notice, or even within 30 days from the issue of the show cause notice, then in such a case, the penalty is not attracted. That is what it is. That has happened in this particular case. So the second case, they took the advantage. As soon as the show cause notice is issued, they have filed the statements. So they actually got rid of this penalty. They escaped actually. And again, there is a accounting standards is not complied with in the financial statements. Here, the companies and the director, they have actually been penalized. The cases are there. There are two cases. There are accounting standard not complied with it. And then financial statement, when it is filed without the cash flow statement. Cash flow statement was not filed. Then there was a penalty on this. And then non-filing of the financial return by the insolvency professional when the company was actually going on the resolution of professional, which has happened. That means compliance is important by anybody and everybody. Even if the board of directors are actually not functioning it is actually transferring to the insolvency professional. It is their responsibility to get the filing done, compliance is done. In this particular case, the penalty was imposed on the resolution professional actually who was involved in the resolution process. That is what it has happened in this particular. Now again, we have come across non-constitution of the committee, appointment of the directors and other KMPs also. We have non-appointment of the audit committee, non-appointment of the remuneration and nomination committee. These are all the things as attracted. In this particular case, if you look at it, it is not only the company, it is the company, it is the managing director, it's all the director. That means whole-time director, non-executive director, and even the KMP. KMP means the CFO and CS both. Everybody has been made responsible in this particular case. Then there is an irregular appointment of the additional director. Irregular appointment of the additional director, as you know, additional director, when it is actually appointed, he holds the position only till the next AGM. After that, either he is to be confirmed as a regular director or he ceases to be a director. In this particular case, he is not regularized, but he continued as a director as such. That is what it has happened. So in this case, there was a penalty. It is a CFO plus past CFO and CS, KMPs. They have been actually penalized on this particular case along with the MD and the company. And again, we come across the cases with the non-appointment of the women director where it is required to be done under section 149 of the Act. We actually came. Then again, independent director, non-appointment. Then one more thing is I come across the resident director. This is one of the things which has been brought in the new Act. Resident director, the person at least should be present in India more than 182 days. In this particular case, it was not the case. So non-appointment of the resident director, which attracted the penalty. Then again, KMP's non-appointment is also attracted the penalty to the tune of some 20 lakh rupees in one of the companies. They are not appointed the CS and the CFO. That is what it has actually happened. Then again, internal auditor has not been appointed. Again, we come across in this particular case, Ahmedabad-based company. Penalty was involved actually for MD and the other directors actually. Then again, the delayed intimation of the director resignation. See, one thing is there, many times we think actually Okay, compliance is not done today, but by paying the additional fees, we have actually done the delayed compliance, the matter is settled, which is not the case. Delayed compliance is done, but still non-compliant persists from the day compliance is required to be done till the delayed compliance done. That is what it has happened in this particular case. So delayed intimations of directors attracted the penalty in between the period. They have been actually penalized in this particular case. And
But I
again,
would
we
add
have,
on to add on to this. You very
yeah,
appropriately mentioned that just by payment of additional fees, we are not absolved from the entire non-compliance. It'll still get attracted. It's just that we're doing it for the time delay as the additional fees. That is nowhere a proof that we are absolved from the entire non-compliance.
yeah, absolutely correct. But the only thing is what happens is, many times if the slight delay is there and other thing and all, the ROC overlooks it, it's okay.
Yes.
That is it. Okay, because I come across the cases, it's a delayed, little bit delay here and there is there. Okay, they just overlook it. They don't take it very seriously. Otherwise, definitely there is a non-compliance is there. And what many people think is, okay, why should we actually go for a, sumoto application, etc. and all this thing. If it get detected, it get detected. Or if it is goes away, goes away. That is the stand many people are actually taking it. That is what I understood from the many people who are actually there. That is the thing. Another thing is that directors are actually paid remuneration beyond the limit of section 197 actually. This is what it has happened. So in this particular case, the MD and the two directors, they were actually penalized for the excess remuneration being paid. That is one thing which is to be careful, because remuneration ceiling limit is there. Within the ceiling limit, orders to remain, that is there. Again, the non-transfer of the CSR amount to the specified designated account, which has not happened, there's a heavy penalty. In this particular case, about 36 lakh rupees as the penalty which has been actually levied in this case, section 135, which has actually happened. Then we come statutory register and the filing of the documents. A, non-maintenance of the statutory register. Second thing, even the statutory register, their entries are not updated. These are the two issues which are actually happening here. So in this particular, failure to maintain the statutory register. Statutory register is there, but the entry is not made from time to time what is required. That is what it has actually happened. Then again, incomplete register. Entries are made, but some entries are missing. It is not there, it is not in complete. That is what it has happened. Again, we come across the signboard outside the register office was actually not there. So here also a heavy penalty was there, 5 lakh rupees. They actually justified saying, the metal plate was actually got damaged. We actually removed it. We sent it for repair, etc. The ROC seemed to have said, okay, you should have put the temporary board till the metal board comes. That was actually the things put forward by the ROC. When the essence is there was no board was there actually when they visited. That was the issue here actually. Then again, the RPT transactions in the statutory say MPP 4 is not actually mentioned. That has happened. So then of course there are come across as Praveen actually has just been actually said, late filing is not ensuring the compliance absolutely absolving your liability. Late compliance only involves you set right the compliances, otherwise what you have done with the time delayed by paying the additional fees, but a non-compliance still remains actually. So these cases actually talks about initially failure to file, but absolutely you set right it, but the intervening period which was there, they have been actually levied the penalty. Of course, the heavy penalty has been levied here, but they got it reversed when they gone to the RD. That is what they have done. Then again, one more thing I come across, the MSME forms. That is the small, medium enterprises. Their return is required to be filed. It is disclosure is to be made in the financial statement, which is actually not made. E-form MSME 1 has not been filed in this case. So that case also, the penalty was paid. The penalty was very heavy in this case, to the tune of about 16 lakh rupees. They have actually levied the penalty on this particular. Then again, the alternation of the share capital, that is basically the SH7. There's a delayed filing. This has happened. Then delayed intimation of the beneficial ownership we have come across. Then again, the NCLT order has been delayed filing. because it is not filed in time. So the section 230, 232 order, which has been passed by the NCLT, that has been filed a delay, which has attracted the penalty. This is what. Then we come to the close to the end of the PPT, secretarial auditor. Discuss in the initially only, I said actually in case of the SR shipping case, 2 lakh rupees penalty, which has been actually taken place here, because this is a related party transaction, basically section involving 186 is an improper approval, etc., which has been taken out the audit committee. That has actually happened. That is one. Sun Pharmaceutical case also I discussed elaborately in the beginning only. In that case, about 1.5 lakh rupees amount has been levied as a penalty, because the material RPT transactions are not pointed out. There is no comment on this secretarial auditor's report, although he took a stand. I relied upon the statutory auditor, nothing is there, and nothing that was not accepted. So in these cases, this was been. And when it comes to the certification, there is a defective PAS3 certification has been done actually. Because, it is wrongly prepared, but without proper verification, certification also done wrongly. That is what has happened in this particular case. It is not only the company, it is company, and along with the practicing company secretary, both were actually penalized in this particular case because defective PAS3 certification, which was actually there here. Because the amount is, wrongly mentioned. That was the case. Then again, in one of the financial statement, erroneous turnover has been actually mentioned. So there also the secretarial auditor for the wrong certification, he has been actually certified filing the SBRL form with the wrong detail. That is what it is. Now again, as I said very clearly, all said and done, yes, non-compliance taking place, and we defend, adjudication order is passed. But as I said, adjudication order, the ROC actually bound by the sections, which is actually spelling out what is the penalty. He does not have any description. He goes simply by the section, whatever the penalty is there, he will simply levy it. No description is there, except the cases where the minimum maximum is mentioned. Yes, there is only the thing. There are very few sections. So if you really have the merit, then you can go on appeal. Even the order mentioned very categorically, you will have to require to file the appeal within the specified time with the jurisdictional regional director, and you can file the appeal. When you appeal, you really get, as Chandan sir puts it, if you have the merit on the case, if the justified ground is there, you really get the relief. These are all some of the relief has been actually given here. This is one of the case which has actually happened with the Hyderabad. 3 lakh rupees penalty has been actually paid for the delayed share certificate issue. So ultimately, they made a justified ground, they have the grounds. So the 3 lakh rupees has been actually brought down to 1 lakh rupees. They've been given 1/3 of the penalty was actually levied. The second case, as I pointed out earlier also, this is actually the penalty amount which has been actually levied to the tune of about 6 lakh rupees has been brought down to 60,000 rupees in the case. This was actually the appointment of the internal auditor's case, which they had done. We discussed earlier also. This has happened. Again, in another case, RD has actually slashed the penalty from 32 lakh rupees to 1.68 lakh. They done actually in the matter of the Saddles International and Aviation Interior Private Limited. This is what it has happened here. So there are possibility that if you are able to justify, if you are able to give the merits, then in such a cases, you can actually get the relief from the RD side. But automatically, you cannot go, as we discussed, by saying that some of the ROC has levied the lesser penalty, so I seek for the lesser penalty. Those sort of the things does not work except. End of the presentations. Any question, etc., and other things are there. You are actually welcome. I think presentation with the quote. We want to see change. But our father of nation said, you want to see the change, you be the change what you want to see in the world. First you change, then you seek for the change. That is what he said. I like this quote very much. I thought of sharing with you. Patience hearing. I close the presentation with this.
Thank you, sir. Thank you so much for that presentation. There are a few questions on the chat box. I'll just start taking that up. Chandan sir particularly I would require your inputs on the same. So, board meeting minutes have to be entered in the minutes books within 30 days. They can be signed by the chairman at the next board meeting. In many meetings, the date below the chairman's signature is not done by him or by the secretarial staff just to comply with the law. What if the ROC wants to check the veracity of the handwriting of the date mentioned below the signature of the chairman? Any case known to you for that? Chandan sir, your inputs
Ah,
on this?
okay. See, the minutes have to be in the minutes books within 30 days, which means that you would have to comply with all the secretarial standards and the Companies Act standards as far as the minutes goes. And a board meeting happening within 30 days to the prior board meeting generally doesn't happen. Even committees don't happen that way. That is why what you should do is you have to send the minutes and get it signed by the chairman of that meeting. Company secretary only signs as an identification. He is not required to sign. Okay, he is not required to sign the minutes. So, and secretarial staff signing minutes and all that, I have not. I mean, it's meaningless because the
Yes,
minutes are private information. They are not
correct.
for world circulation, right? What happens in board meetings, what was discussed by directors. So everything is not
Yes.
for, and so a company secretary even uh, you know giving the minutes to somebody else to number it, all that is not done because that information will flow. And I have seen cases where in cases of performance review of directors for listed companies, that information was leaked because I or other companies have formats in which directors give their views. And so you have to get the minutes signed and from the past chairperson of that and get it filed. So where is the issue? And you have to, and when you send them the minutes, we generally put a sticker, where all he has to sign. The stickers are put. And when the last page will have, you will write date, place, you will leave all that, full signature in bracket. And most chairpersons, and most directors are quite educated. I mean, if you say by the director, he doesn't know, he has to put his full signature. I mean, so you can see as a help, you can do all that. We put tags, plastic tags are available, which says, full signature.
Right. Yes.
So these are, see, as company secretaries, we have to grow. We cannot be talking silly things about, pages are not numbered, what should I do? A director doesn't sign, what should I do? We have grown out of that. The regulators expect you to be at a level of the board, right? You are a KP. Now look at CFO. No qualification prescribed for a CFO. But for a company secretary, you have said it's a company secretary, is a member of the Institute of Company Secretaries of India. It's a big thing.
Yes.
Normally, a CFO is quite a big thing because a CFO manages the entire finance, and the finance is what a company runs on. That's the fuel of a company. But they have not said he has to be a member of anything. So CS has to realize that you are no longer that small boy who people say typist. Oh, acha, you are a secretary, aap kiske secretary ho? Those days people don't ask, the people don't ask you anymore, ki aap kiske secretary ho? And you are asking, how do I sign minutes books? Most board chairmen, and with so much penalties, there are many cases on boards liability, fiduciary, I mean, LODR 25, 20, I mean, 25.5 regulations, Companies Act, so many, I mean, it's very clear. You have code of conducts, even for listed companies, boards, we have code of conduct for directors, we have code of conduct for senior management, right? So after all these, they are not simple things, and you'll be questioned very severely. Your own documents will speak against you. So do not create.
Right.
Jasvi, I spent almost about 20 years with a listed company where I never had any problem, all these things. In fact, not even a single show cause notice, not even a visit to ROC office. I didn't know where is ROC office when I was working in the 20 years in that company. But somehow at the age of 67, I took up the job with the private and unlisted public companies, where almost about 14, 15 companies were there. We used to conduct a series of board meetings. And there are different company secretaries were there. But somehow or other, the managing director of the main company, they told me, Bala, you take care of all these documentations. As Chandan sir puts it, what I used to do, I used to get the minutes book of each of the companies separately. I used to carry, stand in front of the chairman, sir, initial here each page, full signature in the last page, please put the date, please put the place, etc. and all. I used to get it signed, ensuring everything. That is what it is actually called for as a professional, really speaking. So he says it very well, actually. We cannot just leave it like that, because nowadays the way the complaints are looked upon, the way the penalties are being levied, the way regulators approaching the approaches, we need to raise our bar to the extent what is called for, actually. Because one side we are seeking more and more recognition, but the other side we also need to raise our bar to the level of performing, no, just that's what I think. Yeah.
Absolutely. And we have to be more meticulous in the approach also when it comes to law, compliance, or otherwise. That's true.
And I would like to also add on this, especially foreign companies, like say European companies, they are very meticulous. They will never go into non-compliances because they work in many jurisdictions. I've seen Japanese companies, they are very, very careful. German companies, if you tell them, sir, this is what the law of the land requires, they will ask you to do double the requirements. Let me tell you, in one of the matters, I have carried the minutes abroad to get it signed because the chairman of that meeting was one of our foreign directors. So, if you tell them that, sir, this is what is required by law, they don't ask you too many questions. If you simply write to them on an email saying that this is the law of the land, this is what is required, they will ensure it is complied. We presume that they don't care about Indian laws because, see, what happens is they work in 100+ jurisdictions. If you are at wrong, they have to report it somewhere. Your global auditors will report it. Because,
Correct.
so they would never want it. Look at US. US has its own laws. There is a recent case where US wants to prosecute an Indian company because of funding they took from US. So, it is more Indian companies which look at shortcutting. But now even that is changed because of so heavy penalties and earlier ROCs, they are all digitized now. So it's very easy for them to track. Today, ROC, all your filings are e-filings. So, you
Not
cannot
only,
go. Sorry,
yeah.
sir.
Yeah, please go ahead. Go ahead.
No.
Please go ahead.
So it's very difficult to hide your sins. That is the problem.
I have come across, actually, as you rightly puts it, most of the companies who are working in the collaboration, they don't bother about, the question of cost of compliance versus the compliance itself. Because what happened in the Indian, jada kya hoga, it's all right, leave it. Because why I'm telling you, I just wanted to highlight one thing. One of the director was a qualified director, was an independent director. He was the chairman of the audit committee. He was in abroad during the time of annual general meeting. As you are aware, one of the requirement is there. The audit committee chairman is required to be present to answer the queries at the annual general meeting. So we told him this is what it is required. Immediately, it was a foreign collaborated company. He said, whatever it is, we don't want any non-compliance. Please travel back to India, attend the annual general meeting, and then come back. It was actually heavily incurring a cost traveling all the way from abroad to India. And again, to continue to the work, he has to again travel back. They took the decision. No, compliance is the compliance. If your presence is required in the annual general meeting, yes, you need to be there. This is what the call they had taken. The question is how you are concerned about the compliance. That actually speaks that the company's culture, which I would like to say. Yeah.
Sir, sorry.
Yeah,
Uh,
sure, sir.
Sir,
Please
I
go
would
ahead.
like to, another 5 minutes that I leave because I have a matter at 2:30
Sure,
to,
sure, sure.
Yes, sir.
No,
We'll just be wrapping up. Just
uh,
last one question, and then we'll be
yeah.
wrapping up the entire thing. So, and one of the participants has said, "Sir, as per the information, if the company is under IBC, then they are exempted from filing of annual returns. Please correct me if I'm wrong." One of the participants have said that. As per my knowledge, you're not exempted from filing of
I,
annual reports.
I don't think, because I have come across the
Mm.
cases, even the resolution personnel have been actually penalized for the non-compliances. I don't see there is any exemption specifically available and other things and all those things,
Correct.
because compliance
Yes.
is required to be done. Because what happens is that board responsibility again passes over to the resolution personnel. Then they have to actually ensure the compliance. That is my view, actually. That is what I come across with the deserted case laws also. I don't think I have come across any exemption, etc., what your participant is referring.
Mm. Right. If CS is expected to be on the level of board, how then these trivial violations happen and are treated so seriously by ROC?
What is the question?
If CS is expected to be on the level of board, how then these trivial violations happen and are treated seriously by ROC?
You see, we have been given the higher responsibility of ensuring the compliance. What is our job? If you ask me the first question, I'll say it is a compliance. If you ask what is the next job, I'll again answer compliance. Third time also ask me what is your job, I'll say compliance. Because we have been designated as the compliance officer under the LODR regulation. We have been designated as a KMP under the Companies Act. Our job has been spelled out to ensure the compliance not only under the Companies Act, but also all the other applicable acts in a company. In such a case, if we have been elevated to such an extent of the level, how can we actually say whether it is serious or not serious? Now, the cases itself, what we discuss speaks how they are looking after the compliance, how they are actually levying the penalty, etc. Because there is no doubt compliance has to be ensured at any cost. Even if you do the delayed
Absolutely.
compliance, also the compliance is there.
Right. So, just in the interest of time, I think PV Subramaniam sir, would you like to unmute and ask certain things or certain questions, because we're more than we've crossed the 1 o'clock mark as well, and as I understand, Chandan sir also has to go for a hearing.
I think Chandan sir, we should relieve him. We should not
okay.
delay him
Yes.
actually.
Yeah, because I need to
So thank
prepare.
you.
Yeah.
Thank you so much, Chandan sir,
Thank
on
you.
behalf of the entire team of Mehta
Yeah.
and Mehta. I would like to really thank you for your time, your contribution, and giving the practical view of, how to carry out, even when it comes to appeal, and what role does a CS play through the entire process. So thank you so much, sir, for your valuable inputs. Thank you so much, Bala sir, for the presentation. It is as resourceful and you've compiled all the orders, including segregation of the entire non-compliance for which the order was passed. So my sincere thanks to both of you and all the participants for taking out the time on a Saturday to be a part of this. Thank you so much and have a great, great weekend ahead. Thank you.
Thank you. Thank you so much.
Thanks
Thank
a
you.
lot, Chandan, once again.
Yeah. Thanks, Bala
Thanks a
sir.
lot.
And thanks, Jasmine, for all your support. It's very nicely conducted. Because
Thank you. Thank you,
I
sir.
have to prepare for a hearing. So, I cannot preach you and not do what I'm supposed to do. Thank you very much. Yeah. Thank you.
Thanks a lot. Have a good day. Have a good weekend.
Thank you.
Thanks a lot to the participant. Have a good weekend. We yet meet in another session next week. Thank you.